Says former radio DJ Ngizwe Mchunu's release on bail is not a reflection of the strength of their case. The Randburg Magistrates Court earlier today granted him bail. He's one of the people accused of instigating violence that spread to various parts of Gauteng and KwaZulu-Natal earlier this month. Our reporter Silindelo Masikane has been following the case. She joins us now. Hello, Sli. So what are the bail conditions?
Well, there are several bail conditions, Sally, in terms of Ngizwe Mchunu's release on bail. He is released on 2,000 Rand bail, and some of those conditions include the fact that he is not allowed to leave the Durban area unless it is to attend his court cases. He must report to a police station at a certain time and date that will be allocated by the investigating officer. The investigating officer as well has possession of his passport as well as his visas, and also he is not allowed to address any gatherings or host any gatherings, and he is not allowed to incite any propaganda on his social media pages. And he was warned that if he contravenes any of these bail conditions, then the state does reserve the right to apply for his bail to be revoked.
So the NPA is saying the fact that he's got bail doesn't mean they don't have a strong case, but I note they haven't added any charges, any extra charges beyond the Schedule 1 incitement to violence. Tell us a little bit more about what the NPA said in response.
Well, you would remember, Sally, that the state prosecutor, the NPA specifically, was opposing bail. And because it's a Schedule 1 offence, his main charge, really, the incitement of public violence, then the onus was on the state to prove why it's not in the interests of justice that he be released on bail. And if I can just quote the magistrate, she literally said, "I am in the dark. I have no idea exactly what the strength of the state's case is." And because Mchunu is a first-time offender, no previous convictions, he handed himself over to police, then there really wasn't anything the magistrate could go on in terms of what it is that his release would jeopardize the state's case on. And so the state was saying to the magistrate that, look, they can't reveal all their cards at this point. The information that they've brought forward to the court was really to show the court that at this point they believe that he's a flight risk. However, the magistrate was just not convinced at all, really, in terms of the evidence that was brought forward, especially some of the video footage that the state brought, attempting to show the court that he was inciting violence. The magistrate saying, "I didn't see any of that. And if you're saying he's a flight risk, in fact, your evidence proves in his favor, because it shows that actually you don't have a case against him." And he handed himself over to police. And if we do set some bail conditions, obviously if he does not abide by them, then his bail can be revoked. But the state's saying that more evidence will be revealed, and this is just merely the beginning. Let's take a listen.
Well, we are not yet at the stage where, as the state, we are in a position to state our case. Here it was simply proceedings of a Schedule 1 bail hearing. The onus was on the state to prove that it is not in the interest of justice that the accused be released on bail. And yes, the court made comments that it is satisfied with the charge of contravention of Disaster Management Act, but however there was no evidence to support the incitement to commit public violence charge. So we are saying, as the state, these are the early stages. Much of the information will be revealed during trial.
All right, so they're saying more is to come. What is Mchunu's lawyer saying?
Well, of course, they welcome the judgment. They believe it's the right one, saying the state really was grasping at straws at this point, and at no point did they submit anything to the court that would justify Mchunu being remanded in custody on a Schedule 1 offence. Let's take a listen.
We try earlier on to discuss the state and show them that the strength of their case is still in doubtful stage at this stage. and they didn't agree to that with us. Then we decided to move the matter to as a formal bail application. We presented our case as according to the Criminal Procedure Act, subsection 60, subsection 4, and the court agreed with us that at this stage the strength of the state case is still open to some doubt, which worked in the favor of the accused. So it was in the interest of justice. The court has no choice because it is a creature of the legislature. It needs to follow those guidelines. Then it said it was beyond its control. So the interest of justice determined that our client is a good candidate for bail.
All right, so obviously Mchunu's lawyer quite confident, and the NPA saying all will be revealed during the trial. So I guess we'll just have to wait and see. Thank you so much, Silindelo Masikane. And now